that time of the week again when Stephanie Dobson joins us. Stephanie is a lawyer, mediator, and online educator with Hank Divorce Law and Mediation, offices in Edmonton and Lloydminster. Stephanie, thanks for joining me today.
Thanks again, Stacey.
Today, we are going to be talking about collaborative law and what happens when the process breaks down in that. So, first of all, can you explain to me what is collaborative law?
Sure, and this shouldn't be unfamiliar. This should be familiar, I should say, to our viewers from some of our past episodes, but I'll just do a little refresher. So, the collaborative law is a process that focuses on finding resolution to post-separation issues in a way that works for both parties. So, it's a negotiation process where each party has a specially trained collaborative lawyer who helps them to resolve their separation and divorce issues cooperatively with a focus on the needs and interests of their family. So basically, you're contractually agreeing to work as allies as opposed to adversaries to arrive at resolution. And in the end, we try to achieve resolution without court intervention. And that commitment to staying out of the courtroom is fundamental to the process. So it's a commitment that you make right at the start of the process, and it works in both parties' favor.
And now, what happens when that process breaks down?
Well, we'll say if the process breaks down. How about?
Okay, perfect.
Because it's really important. Excuse me, it's really important to qualify that the collaborative process is appropriate for people before you even go into it. But um, in that collaborative law contract, there's what's called a disqualification clause. And that means that in the event that you reach impasse or for the process breaks down for whatever reason, the parties have to hire new lawyers to finish off their case. Now, I can appreciate that that might sound like a disadvantage. And that's why I wanted to focus on this today, because it's actually not a disadvantage. It's of prime importance to the integrity of the collaborative process and to protecting the parties' confidentiality. So in the collaborative process, in the meetings that we use to resolve everything, the parties will share information with one another really transparently, and it would be a disservice to the lawyers, to the parties, if the lawyers were able to carry on that in litigation after the process ends in impasse with that information. So that complete transparency and teamwork is incredibly important to the process, and it's for protection of the parties that you have that disqualification clause.
And so now, if things go sideways, Stephanie, do you have to completely start over?
So the question, it's a really good question. And I always say, what does start over really mean? In a way, some parts may have to be started over, but other parts may not have to be. So if, for example, in any legal process, there's documents that will need to be exchanged between the parties. So the general rule is that if there's documents that are disclosable outside of the collaborative process, things like tax returns, bank statements, business financial statements, those are things that are produced in any event, collaborative process or not, they can be used in a next process. But documents that were created within the collaborative process, things like business valuations and appraisals, cannot be used outside of the process without the consent of all the parties and the person who created the document. Now, if some issues were settled, you might not need to fully start over. So for example, there's a myriad of issues to be resolved within the collaborative process. So for instance, you have parenting and you have property division. So say you resolve parenting, but property division was that thing that broke down. Well, you may want to take that the parenting agreement and actually put that into a signed separation agreement just with respect to the parenting side, and then have the thing that needs to be litigated, the thing that got you to impasse being the property division, you may want to put that on to into the litigation sphere. So the last thing that you might be able to use outside of the collaborative process that I had thought of getting ready for today's interview is interests and goals. So things that are important to the parties um, in their life, in their post-separation life, that drives them to want certain resolution. Those are the kind of things that you can certainly take to your next lawyer, and it helps the lawyer to understand the parties and the case a little bit better. So hopefully that could be used outside of the process.
So, what is the likelihood, Stephanie, that this actually will happen, that you'll get to a point where there's an impasse and then you do have to hire some new lawyers?
Well, and that's why we started this with an if, not when, because it does sound like a big deal, but the chance of getting to impasse is very low. So I've done about a over around 100 or so cases in the 17 years that I've been practicing, and there's less than a handful of cases which have resulted in impasse. I couldn't think off the top of my head, but somewhere around less than a handful of cases. But the most important thing that you can do is to have that proper analysis done of your case before starting the collaborative process to make sure that you're an appropriate candidate for the process. So I always say if you're using a process outside of the courtroom, it's called appropriate dispute resolution. Not the ADR isn't alternative dispute resolution, it's appropriate dispute resolution. So let's focus on choosing that appropriate process for your particular case.
All right, Stephanie. Well, thank you so much for joining me this week, and we will chat with you again next week.
Thanks, Stacy.